House Joint Resolution Constitutional Amendment 28 proposes to make change to our state constitution that we are quite familiar with, but one we cannot overlook because it is language that has proven truly transformative. The Federal Voting Rights Act of 1965 and its 1982 amendment took historic steps to secure ballot access, enfranchise historically marginalized groups, and combat discriminatory practices most commonly exercised by Southern states. Consider this. Before the Voting Rights Act, Black representation in Congress consisted of 5 members. 5 members. And towns across the country were racially gerrymandered in such a way that there was no minority representation on school boards, city councils, and in state legislatures. The Voting Rights Act of 1965, 1982 amendment, and case law interpreting its provisions for over half a century increased that number 12-fold. And today's 118th Congress is the most racially diverse in our country's history. But we saw in 2012 the first attack by an extraordinarily partisan U.S. Supreme Court when it gutted the pre-clearance requirements. Now, we find ourselves in a familiar situation. Our current and even more radical U.S. Supreme Court is currently considering gutting Section 2 of the Voting Rights Act altogether. It is undeniable that this U.S. Supreme Court is poised to dismantle these protections, and when it does, some states will quickly undertake new gerrymandering schemes aimed at stripping away Black and Latino and other minority representation. Here in Illinois, we refuse to go back, regardless of which party controls the majority of our state legislature. Put simply, House Joint Resolution Constitutional Amendment 28 ensures that no citizen on account of race is denied the opportunity to elect the representatives of their choosing and take steps to ensure Illinois voices are not silenced, no matter what happens in Washington. I'm here today, members of this distinguished committee, to ask for an aye vote and move this to the full floor for a full debate.